Hello, welcome to Partnership Law. So our partnership law is included in Book 4 of the Civil Code, the book on obligations and contracts. Okay, but it is under Title 9, which includes Article 1767 to Article 1867 of the Civil Code. Okay, as you can see, it is under Title 9, while the obligations and contracts subject, uh, if you could remember, it is under Title 1 and Title 2 of Book 4. This partnership is under Title 9. Okay. Okay, so let's proceed with the discussion regarding partnership law. Now, first is the contract of partnership. Okay, so what is a partnership or a contract of partnership? Now, under Article 1767, it is defined as a contract whereby two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So, as you can see, it is a contract which can be entered by at least two persons because it is uh, pointed out here or stated here in the definition that it could be entered into by more than two persons, right? So even if it's called the partnership, it could be entered by more than two persons, maybe five or ten. It's all right. Okay. What is important is they contribute either money, property, or industry. Okay, so in that money, property, or industry, they will um, collect it and put it in a common fund, uh, which this common fund will be used for their um, business. Okay, and from that business, of course, they will derive profits, and then that profits will be divided among the partners. So that is a contract of partnership. So as you could, as you could see, the uh, the intention really here in definition of the partnership. The intention of the partners who put their money, property, or industry to a common fund is in order to derive profits and to divide those profits among themselves. Okay, but there is another type of a partnership, okay, whereby um, the essence of the partnership is not really the business of deriving profits for the purpose of deriving profits, but is for the purpose of the exercise of their profession. Okay, and that is what we call a general professional partnership. Okay, so under the definition given by Article 1767, it is not only for the purpose of deriving profits, purely business na partnership, but it could also be for the exercise of profession, which is specifically called a general professional partnership. So that is the definition or definitions of partnership. Now let's proceed to the characteristics of a partnership. Okay, so how do we um, this is part of the question which we may ask, uh, how do we distinguish a partnership from other contracts? Okay, but because uh, if you could see, it is a contract, right? But there are different types of contracts. So how do we distinguish a contract of partnership from other contracts? So first is we need to identify what are the characteristics of this partnership. We have to know the characteristics of a partnership or a contract of partnership. Okay, but uh, in advance, determining the characteristics of a partnership is not the sole or the only way of determining or distinguishing a contract of partnership from other contracts. So, first characteristic of a partnership is that it is a consensual contract as a general rule. So, as you have learned in your subject in obligations and contracts, if we say a contract is consensual, it means that it is perfected by mere consent. Okay, so it doesn't need the delivery of the object or the performance or the compliance with the formalities of the law. The mere consent or agreement or the meeting of the minds of the parties creates a contract of partnership. So even if, so it's a general rule, even if the contract is not written or is not in a public instrument, okay, that contract of partnership is perfected by mere agreement of the parties. Okay, consensual. Next is nominate contract. Okay, as you have also learned under your contracts, obligations and contract subjects, or specifically in the contracts topic under Title 2 Book 4, um, you could see that this partnership is nominate because it is designated a special name under the civil code, right? Uh, as you have already, or as I have already mentioned kanina, so this contract of partnership has its own title under the civil code. Okay? It is specifically designated under the civil code in Title 9 of Book 4. So that is nominate. Okay? Because otherwise, if it is not provided under the civil code or in any other special laws, then it doesn't have a name, it doesn't have a designation, or it doesn't have any laws governing that contract, then it is called an innominate contract. But since partnership is designated under the civil code with a specific title and a specific name, which is partnership, then it is a nominate contract. Okay? Then third is it is bilateral. Okay? So the rights and obligations arising from the the contract of partnership is always reciprocal. Okay, so it is not only one of the parties who is um, obligated or has an obligation to the other one, but all of the partners or the persons who entered the contract of partnership has an obligation to each other. Okay, so that is why it's called bilateral. Onerous. Fourth characteristic is onerous. Okay, the parties aspires to procure for himself a benefit through the giving of something. So it's not like you just enter into a contract of partnership without without contributing something, and then you derive profits, okay, from therefrom without even contributing money, property, or industry to the common fund. And okay, so before you can derive profits from the partnership, you must have had contributed either money, property, or industry in that partnership. And then, so that's in onerous. And then number five, a contract of partnership is commutative. So it means that the undertaking of each of the partners is considered as the equivalent of that of the others. Okay, so even if one of the partners contributed money to the common fund, and the other partner contributed industry to the common fund, then it is generally considered as the money contributed and the industry, the money contributed by one partner and the industry contributed by the other partner are considered as equivalent. Okay, so that's commutative. Okay, they are not the same object, but they are considered as equivalent. Number six is it is a principal contract. So I think you have already knowledge about what is a principal contract, right? If we say principal contract, it means its existence as a contract does not depend upon the existence of another contract, because otherwise it would be an accessory contract. So a contract of partnership can exist by itself. It is not dependent upon any other contract. Okay. Number seven, it is preparatory. If we say preparatory, then a contract of partnership is entered. Okay, a contract of partnership is entered into as a means to an end. So the partners do not enter into a partnership for the sake of just entering a partnership, right? Okay, they enter into a partnership because they have another purpose. They enter into a partnership because they want to do a business. Okay, they contributed money, property, or industry to a common fund, not just for the sake of creating a partnership, but they contributed those things in order for uh, to conduct a business. Okay, to establish their business, their venture. So a contract of partnership is merely entered as a means to an end. It does not end there. The entering of a contract does not it does not end there to the entering of the contract. But the contract of partnership is entered for the purpose of doing the business, and then uh, gaining profits from the business, and then dividing the profits among themselves. Right? So those seven things are the characteristics of a partnership. Okay, so more or less we can identify a partnership by those characteristics, but uh, not that would be not conclusive if we just depend or look into the characteristics of a contract. So we have to see the elements. Okay, we have also, of course, if still a contract of partnership is a contract, so therefore it has to um, to comply with the basic principles provided in the contracts. So the elements of the contracts, right? So as we already know this in the subject obligations and contracts, a, a contract of partnership being a contract still has to comply with the elements, with these elements. First is the consent of the contracting parties. Second, object certain, which is the subject matter of the contract. And third is the cause of the obligation which is established. So we already know that. We will not discuss it further. Now, the essential features, let us go to the essential features of partnership. So this is the more conclusive test or test which we can use in order to really identify uh, or distinguish a contract of partnership from other contracts. Okay, so first there must be a valid contract. Okay, that is for uh, under this first essential feature, we just have to identify whether or not the elements of a contract are present. Otherwise, there would be no valid contract if the one of any or all of the elements are absent. Okay, so first there must be a valid contract. Second, the parties must have legal capacity to enter into the contract. Okay, if we say legal capacity, that relates to the persons entering into the contract, whether they are minors or not, or deaf mutes. Okay, so it relates to the capacity of the parties entering into the contract of partnership. It says here, in order to identify a partnership, there must be the parties must be legally capacitated to enter into the contract of partnership. And then third is, from the definition of the contract of partnership itself, there must be a mutual contribution of money, property, or industry to a common fund. Okay, so this is a very important essential feature of a partnership. Okay, there must be contribution. That is one of the most important essence. So it's either money, property, or industry that is contributed to the common fund. And then the object must be lawful. So okay, so you must have entered into the partnership for lawful purposes. Otherwise, the partnership would be invalid. If you enter into partnership for the purpose of dealing drugs or for any other purpose contrary to law, then that partnership would be invalid, or there it's as if the contract is void, right? There would be as if no contract at all. Okay, so that's another one important feature. And then the fifth, okay, I think the most important feature of a contract of partnership is that the primary purpose why you have entered into a contract of partnership must be to obtain profits and to divide the same among the parties. Okay, so that is why you entered into a contract of partnership. You contributed money, property, or industry to a common fund is for the purpose of obtaining profits and to divide the same among themselves. Okay, so if you have contributed money, property, or industry to a common fund, but the purpose is not for obtaining profits, okay, you did not use the money, property, or industry to the business, but for some other purpose, okay, other purpose aside from obtaining profits, then that is not called a partnership. Okay, it must be for the purpose of obtaining profits and dividing the same among uh, the partners. Okay, so that is the very important feature of partnership. Okay,